Breach of contract and remedies. Contract can be discharged in four ways. By agreement, both parties agree it is supported by the consideration. By frustration, by performing an obligation becomes impossible. By performance, all contract terms performed. By breach, one party fails to meet its obligation. Now, a fact of breach of contract. A breach is where contractual obligations are not performed. However, sometimes a performance has a legal excuse not to perform the obligation, and so this would not be breach. These reasons may be treat the contract as discharge and sue now. Okay, in performance was right. So just a second. Just a second, folks. So the reasons may be impossible performance due to unforeseen event. Performance was rejected. Other party made it impossible. Frustrated contract parties agreed non-performance. Okay. Now, effect of breach. The breach of a condition, as we know, means that injured party can repudiate the rape of the contract, and we call this is a repudiator breach. Okay. Um, Repudiator breach. The injured party can choose to repudiate and claim damages. An anticipatory breach. A declaration in advance not to do so, not to do your side if the bargain, treat the contract as discharge and sue now. Happened in Foster versus Dealer Tour. Complete their end of the contract and then sue in full. White and Carter versus McGregor. So a straightforward repudiatory breach tends to happen at the time of performance. The anticipatory breach happens before the performance is due. Now, damages. Damages are common law remedy. The idea is to put the innocent party in the position it would have been if the contract had been performed. In a claim for damages, the amount is quantified by looking at two rules: the reportness of the damages, the measure of the damage, the remoteness of damage. Hardley versus Baxendale. Uh, where losses must have arisen naturally from the beat, if both, not both, the the parties reasonably must have been aware of the probable result of the breach, right? And the measure of the damages. Remember, this is to put the injured party injured party uh, where they would have been in the contract had been performed. They shouldn't get any more than that from it. Here's things are considered: expectation interest, market price, rule, non-financial loss, mitigation of loss, liquidation, damages. Other common law remedies are action for price. This means asking for price in the contract to damages. The item bought so must have passed to the buyer, and the seller is then suing for the price agreed. Then we have quantum merit. It means how much is it worth? and the claimant is asking for this value for the work they have done, basically to be put back in the position they would have been had the contract never been made. Okay. Now, equitable remedies for breach of contract. These are where common law remedies are not enough. They are based on fairness. Therefore, the claimant must also have been fair, innocent. So we have two types of equity remedy. One is specific performance. This is the court ordering someone to complete their contractual obligation. It will not be made if, when minors are involved, the court can't ensure the performance was over a period of time, where a contract is for a personal service for reasons above, or injection, that is, this is enforcing a contract of negative restraints. So this means stopping people continuing to break their obligations. And recession, this means putting the parties back to where they were before the contract. Four conditions must be meet over here. One, possible to take parties back to their pre contract conditions. This right to rescission was made within reasonable time, the contract has not been affirmed within reasonable time, and finally, the innocent third party isn't affected. That is, they have not got the goods in the contract. So that's it for this part of the session, and I hope you get it. See you. Take care. Bye bye.